Today, Friday, May 22nd, 2026, United States Citizenship and Immigration Services, also known as USCIS, will grant adjustment of status only in extraordinary circumstances. Released today from the Washington office, USCIS today announced a new policy memo reiterating the fact that, consistent with long standing immigration law and immigration court decisions, aliens seeking adjustment of status must do so through consular processing via the State Department outside of the country. Officers are directed to consider all relevant factors and information on a case-by-case basis when determining whether an alien warrants this extraordinary form of relief. We're returning to the original intent of the law to ensure aliens navigate our nation's immigration system properly. From now on, an alien who is in the United States temporarily and wants a green card must return to their home country to apply, except in extraordinary circumstances. This policy allows our immigration system to function as the law intended instead of incentivizing loopholes. When aliens apply from their home country, it reduces the need to find and remove those who decide to slip into the shadows and remain in the United States illegally after being denied residency, said USCIS spokesman Zach Collar. That's a quote. Non-immigrants, like students, temporary workers, or people on tourist visas, come to the United States for a short time and for a specific purpose. Our system is designed for them to leave when their visit is over. Their visit should not function as the first step in the green card process. Following the law allows the majority of these cases to be handled by the State Department at U.S. consular offices abroad and frees up limited USCIS resources to focus on processing other cases that fall under its purview, including visas for victims of violent crime and human trafficking, naturalization applications, and other priorities. The law was written this way for a reason, and despite the fact that it has been ignored for years, following it will help make our system fairer and more efficient. Okay, so in regards to this particular memo they put out today, Friday the 22nd of May, 2026, there are some things in here that make me believe there will be several lawsuits flying. And my advice is, if this affects you or someone in your family, they need to really get on the good foot in the next few weeks and pursue suing. Many people are not aware that last year, 2025, the United States Supreme Court ruled basically against most individuals benefiting from a class action decision or a national injunction, which means that, unfortunately, if someone who was wealthier or had more money or had the funds to sue and the ruling affected many people, you got the benefit of enjoying or taking advantage of that ruling if it was in your favor, even if you did not sue. Now that the rule has changed, you must participate in a lawsuit. And if the lawsuit, you with the other plaintiffs, if you win, you are protected and they must process you accordingly. If you don't participate in any lawsuit, you don't get the benefits of the decision from the court. So if they do start to sue, because many cases have already been paid for, right? USCIS has received fees. They're in process. And many people are just waiting for the case to be decided upon. And now if your case is now moved to the consular track and now you are out of compliance by being here in the United States physically, that is a major change. And they gave no notice. They didn't give any notice to anyone 30 days, 60 days, 90 days, 120 days, whatever, half a year to say, this change is coming, you need to leave. This puts many people out of compliance, would then technically make their presence physically here in the United States illegal. And you may say, this doesn't apply to me. Here's how it affects people back home in other countries who are applying. If you're at home applying, you're already on the consular processing track, okay? What this is doing is saying that all these other cases, which there are hundreds of them, hundreds of thousands of them, they're going to put them in the consular processing track, which would then back up the embassies even more. So the wait times at the embassies may be 1, 2, 3 years. They will be extended now for various visa classes because all of those cases are now going to be pushed to the consular embassy processing or consulate processing and not stateside here in the United States. So let's walk through the different types of cases this could affect, okay? So currently, before this change, this rule from USCIS has been published today. These are the most common eligible visa types and categories for adjustment of status. Let's just go through them. K1, which is a fiance visa, and K3 would be the children of the fiance, if you will. These they have immigrant intent, so that whole process is to adjust status when you get here. That's baked in. So I don't believe that fiancés and the children of are affected necessarily, okay? The immediate relatives of United States citizens, so spouses, unmarried children under 21, and parents of adult U.S. citizens. This would apply to you. Now, mind you, if you're already processing at the consular level, this doesn't apply to you. But if you are here and you are married to a United States spouse or a child of someone who was now newly married or trying to convert status, this does affect you. Children and siblings, also H-1B, L-1, O-1, P as in Paul 1, R-1, temporary work and specialty visas, E-1, E2 visas, okay? EB1, EB2, EB3, employment-based immigrant petitions. This affects those as well. Asylee and refugees, this affects them as well. Now, in their memo, they addressed victims of crime and human trafficking. So I'm assuming, based on their memo, a U as an umbrella, T as in Tom visas, which are victims of qualifying crimes and victims of human trafficking, those are protected. And then VAWA, self-petitioners, which are abused spouses, children, and parents of U.S. citizens or lawful permanent residents. But this is not good for many immigrants. And like I said, people who are in ICE detention right now, who were picked up, may be waiting for their case to just be processed. And now that they're going to rule this way, the case won't be processed. It may be moved to the consular track. And we don't know how long it's going to take for them to systematically, anyway, move all of these cases to the consular system for processing. So they haven't given a time frame on this. It's just, this is not a positive for many at the embassies. It's just going to take longer. And for those who are already in the process of filing for their children or their spouses, I would say make sure your application and your case and your documents are so good and submitted well and organized well, and you can speak to it well at the embassy, because you only had one shot at the interview, but now you're really going to, because these foreign officers are going to even be more taxed. Their caseloads are just going to quadruple overnight. And the line is just going to be longer. And if they have to come back around to you to ask you a question about a document, something that's not clear, you cannot speak to it, you will not get the chance. The likelihood is very small now. No one's going to have time to entertain any mistakes. So make sure that your case applications and documents are error-free and organized well and labeled well when you upload them to the USCIS system and also the CEAC system for consular processing.